Good morning and welcome to the Utah Land Use Institute seminar on homeowner associations and details. We're excited to share the information that'll be provided to you here. Just a couple of items to mention. There are a few PowerPoints that'll be involved in the conversation today. They are available online right now. That is, Jeremy and Scott's are available. And we'll upload Le Mans if it's available to us. They are at utahlanduse.org, and then hit the workshops tab, and you'll see there at the top a list of different seminars we've had, workshops, and one of them will be the HOA workshop, and there the PowerPoints that will be available, whether you're watching this online live or whether you're watching it as a streaming. It'll be available there for you to have the PowerPoints and to avoid a little bit of writer's cramp. The other thing I would mention, again, this applies just to those who are watching live. If you'd like CLE credit, please email your name and bar number to info@utahlanduse.org. And that I will put that email address in the Q&A for the webinar as well, so that you don't have to necessarily lose it if you didn't have a pencil. We'll do some double checking and make sure we get that right, and we appreciate the bar and its support. That said, let me also thank those who've made this possible. The Division of Housing and Community Development in the Utah Department of Workforce Services have provided funding to provide modest honoraria to our main presenter, and also to provide this web streaming and to put it online for permanent use, as long as it's relevant. We also appreciate the Office of the Property Rights Ombudsman in the Department of Commerce. Through the 1% Building Permit Fund, they have been able to provide funding for the Utah Land Use Library, which is another tab at utahlanduse.org. And this seminar, as well as other materials and streaming sessions, are available at the library and will be, again, permanently as long as they're relevant. We are grateful to the Ombudsman's Office for the funding that runs the management and maintenance of that. We also appreciate the SJ and Jesse E. Quinney Foundation. They're our long-term supporters, help us with tremendous support, and have done it for a long time. So we very much appreciate all that. Let me introduce Jeremy Johnson, who's in charge of the discussion today, and he can give us a little more information about his background and introduce the speakers and outline the program. Jeremy, please proceed.
Great. Thanks so much, Craig. Now, can I share my screen so that I can pull up my PowerPoint here?
Yes, go right ahead.
And where's the share screen button?
If you click at the bottom of your screen, a new menu will open up and you'll see it there.
Okay, thanks. Okay, can you all see that fine? Okay, great.
Yes,
well,
we're good.
Thanks, Craig. Appreciate that. So I would also like to thank the Land Use Institute for asking us to put together this book and this presentation for what may be the most boring book in the history of the world. If you don't have some strong connections to HOAs, you should probably ask yourself, what are you doing here? But I will say, however, that if you do deal with HOAs, I'm sorry, but this will actually be very interesting and informative. And I'm confident that it'll be a fantastic resource. And the book, when it's finished, will be a fantastic research as well. And so I do appreciate this opportunity. And it's good to work with Craig again. So a little bit about myself. My name is Jeremy Johnson. I'll be the first speaker, and I'll introduce myself now, give my presentation, and then introduce each speaker when their turn comes. I'm an attorney at Jenkins, Bagley, and Sperry, and our firm focuses on real estate law and especially HOA law. And my background is a little bit unusual for an HOA attorney. I started practicing land use law at Anderson, Call, and Wilkinson with Craig Call. And that was a fantastic opportunity. I learned a lot from Craig and Kevin Anderson, especially. And then while I was practicing law, I took an entrepreneurial detour. My neighbor owned a condominium unit in West Valley, and he was really frustrated with the way it was being managed. And so he came to me and he said, "Hey, you know what? I think that I can run a property management company better than these guys. I'd love your help to kind of take care of the legal aspect of it, and I'm gonna start an HOA management company." And just so you know, this is the way that 97% of all HOA management companies start. Is they have a frustrating experience, they think that they can do better, and they go out and they do it. And things went well for us. I stayed practicing law because I'm a very nervous person by nature. And so I didn't want to kind of go off and take this risk, but my business partner did. And I provided support in the background. While I was continuing to practice law, our business started to grow, and I started to feel a lot of the pressure that comes with being an attorney. And one time we were representing the Salt Lake airport, and I had spent 3 straight nights sleeping on the couch in my office. And I was talking to my business partner and kind of complaining. And he says, "You know, you're always whining. Why don't you just come over and help us grow this business? It's going pretty well. You probably have to take a little bit of risk and a pay cut for a while, but it's doing good." And I kind of took this leap at that time and decided to do it. And I absolutely loved it. You know, for the most part, there's aspects of every job, and especially managing HOAs, that can be frustrating. But I really enjoyed it. I enjoyed building a company, and I enjoyed working with people, especially in HOAs. And we did great. The management company, which was called Advanced Community Services, or ACS, became one of the largest HOA management companies in the state. And it was going along great. And then kind of another detour hit, and that was that my business partner, Ryan Bonham, who is the one that kind of took the risk and did a lot of the lion's share of the work, he wanted to build a hockey rink, and I did not want to do that. So he and I got together, and we figured out a way so that he could go forward and they could buy me out. And that went great. I'm really appreciative to Ryan. It was a really good experience. And I feel like we came to a situation that was good for both of us. But then the question was, what do I do next? And my wife told me that I could not stay at home. I had to work. And I had this great relationship with Jenkins, Bagley, and Sperry. And so I went to them and I said, "Hey, while I'm trying to figure things out, can I work on some projects?" And they said, "Sure, absolutely." And it just went fantastic. I loved Bruce, and I loved Quinn at Jenkins, Bagley, and Sperry. I had known them beforehand, and they came to me and said, "Hey, we'd love for you to work full time." And so I decided to do it, and I have absolutely been delighted in working in the law again. I feel like I kind of have come back to it with new eyes and a fresh start, and it's been fantastic. Now, I explain all that because I think that my experience having managed HOAs and also practicing HOA law gives me a unique perspective into HOAs and into HOA law and into dealing with HOAs. And hopefully I can share that experience with you guys today. one thing about my part of the presentation is that I'm going to be a little bit more basic in my presentation. I'm going to kind of be an introduction for the whole forum and for the other presenters and their topics. So I'll be focusing my topic and my presentation not just to like HOA attorneys, but to local government folks, to homeowners, to developers and real estate agents. And then the other presenters will kind of delve deeper into the specifics of HOA law and more specific topics. So as an introduction, I guess the biggest question that we should start with is, what exactly is an HOA? And I think that probably all of us, when we hear that, it sounds like a pretty basic question that should have a simple answer. But in fact, it's pretty complicated when you get into it. And in some ways, it reminds me of the ancient Indian parable about the blind men and the elephant. And probably a lot of you are familiar with that story, but for those who aren't, it goes like this. So there's this group of blind men, and they hear about this strange animal called an elephant that's been brought to their town. And they're curious about it. They want to learn about it. It's kind of sort of the newsworthy thing that's happening in their village. And so they seek it out of curiosity, and obviously they can't see it. So the way that they try to come to understand this elephant is by feeling it. And so when they approach it, the first person whose hand lands on the trunk says, "Oh, well, this is like kind of like a thick snake." And the second blind man says, "Wow, that's cool." And so he reaches out to feel it, and he grabs it by the ear, and he says, "Well, what are you talking about? This is nothing like a snake. This is more like a fan." And the third blind man is like, "Well, that's weird that you guys would have such different understandings about it." And so he reaches out and he grabs it by the leg, and he immediately is struck by how different it is than what they've described. And he says, "What are you talking about? This is like it's like a pillar. It's like a tree trunk. An elephant's like a tree trunk." So then the fourth one reaches out and touches its side, and he says, "Well, no, you're all wrong. It's like a wall." Another one grabs the tail and says, "To me, it feels like a rope." And then finally, the last one grabs the elephant's tusk and says, "Well, this is long, narrow, and sharp and hard like a spear." And they kind of start to argue about what the elephant's really like. And I think that approaching HOAs can be very similar to this, because HOAs and HOA law have a lot of different facets to it. And if you focus on that one, you might see really well what that aspect of it is like, but you might miss the whole thing together. And part of the reason for that is because there are so many different parts of it. And let me kind of talk about some of the different parts of HOAs. So an HOA can be a community. It can be a contract. In fact, HOAs, the governing documents are constitute a contract. And so someone new to HOA law might look at that and say, well, HOA law is contract law. And then another person might say, well, all HOAs are kind of created as part of a new subdivision. So HOAs are a lot like land development. And then you've got HOAs that parts of it are nonprofit or corporate law. It deals with collections, FHA, insurance, and a lot of other things. And I think that the best place to start, despite all those different aspects of an HOA, is with the statute. But even that isn't simple, because in Utah, there's actually two association acts: the Community Association Act and the Condominium Ownership Act. And the Community Association Act, I think, is probably what most people think of when they think about an HOA. it has to do with like single family homes usually, but not always. It can have townhomes, and rules that dictate how people are going to act in the community, how they're going to maintain their homes to kind of keep up property values. It might have common area like a clubhouse or a pool or a park. And then the second, the Condominium Ownership Act, is sort of like HOAs for condominium units. And they have rules for the condos, and they deal with those units. But these different acts have different even definitions for what an association is. And so the first thing that anybody dealing with an HOA should do, the first question that they should ask and answer is, which of these two statutes applies? And usually that's going to be determined by the governing documents. They will subject the association to either the Community Association Act and the Condominium Association Act. So the Community Association Act, and I've got that pulled up, the statute for the definition of an association in the Community Association Act. And it says, as you can see, except as provided in subsection 2B, association means a corporation or other legal entity, a member of which is an owner of a resident, any member of which is an owner of a residential lot located within the jurisdiction of the association as described in the governing documents, and by virtue of membership or ownership of a residential lot is obligated to pay real property taxes, insurance premiums, maintenance costs, or for improvement of real property not owned by the member. And so those obligations pretty much include anybody that is within the HOA, because if you own land, you're probably going to pay taxes and insurance. And in the association, you're going to have to deal with maintenance costs. The two key provisions that I think then that distinguish an HOA or association in this definition are that it's a corporation or a legal entity, and that it has governing documents. And I think it's interesting that, and I think it's deliberate that they mentioned that not only can it just be any legal entity, but a corporation or other legal entity, because they could have said any legal entity and that would have included corporation. But I think that there's a preference in HOAs to incorporate, and probably specifically to incorporate as a nonprofit corporation, as we'll talk about later. So that's the definition for association under the Community Association Act. The Condominium Association Act is a little bit different. It defines an association of unit owners or association and says that it means all of the unit owners acting as a group in accordance with the declaration and bylaws. So again, we've got governing documents, or organized as a legal entity, again, and that one's more broad, right? In accordance with the declaration. And so again, the key is this legal entity and governing documents. Those two things, or at least if you don't have a legal entity, you've got a group. And so those two things are present in all associations. Now, that helps us kind of get like a broad understanding, but I think if we go back to those different characteristics, kind of those different parts of the elephant that we talked about earlier, they give a better understanding of what HOAs are like. And so one of those that we mentioned was that HOAs are a creature of contract. And in fact, in Utah, the Utah Supreme Court, in a case called Swan Creek Homeowners Association versus Warren, said the following, and this is actually pretty important. It says the governing documents of a homeowners association, including the recorded CC&Rs and bylaws, constitute a contract between the association and the property owners. And the word constitute is especially important. In most states, the governing documents are construed as a contract. So you would interpret as a contract, and that's what it says. But in Utah, it has this interesting language where it says that it constitutes a contract. And this takes us a lot of interesting places, because now we're not just interpreting the governing documents as a contract, they are a contract. And if the attorneys in the room were able to just kind of field questions, and I don't want to do that because it's difficult on a webinar, but if I said, hey, look, somebody's bringing a breach of contract against your client, what are the first defenses that you would raise to combat this claim? I think probably very quickly you would have somebody say, well, the prior breach rule or the first breach rule. And for those who aren't attorneys, let me explain just really briefly what that is. And it's a pretty basic concept. It says that if somebody else, if the other party breaches the contract, then I don't have to perform under the contract. Why should I be obligated to meet the terms if the other party already breached them and violated them? I shouldn't have to. And so in contract law, there's often this argument about who actually breached the contract first. And in the context of HOAs, I think that this could and has become very interesting. So imagine, let's say that I'm minding my own business and I open the mail one day and there is this notice for a fine. And it says, hey, Jeremy, you haven't been putting away your garbage cans, and so we're going to fine you. And I disagree with that. And so I don't pay the fines and I don't put my garbage cans away because it's my property. Who should be telling me what I can do? Well, the HOA becomes really frustrated, and so they bring a complaint and they file that in the 4th District Court because I live in Utah County. And I get served, and all of a sudden I've got this crisis. What do? I'm being sued. Well, if I'm going to argue that the prior breach rule is in effect because this is a contract, what if the HOA hasn't done a great job maintaining the common area? What if the clubhouse has shingles missing and it's leaking, or there's weeds all over the place? I think that under this contract theory, I could say, I don't have to follow the governing documents. I don't have to bring in my garbage can because the HOA, who I'm supposedly in this contract with, they violated the terms of the contract first. And that has actually happened. In fact, in the case that we cited, I'm going to go back really quick. So you've got these two cases. You've got Kelly v. Timber Lakes Property Owners Association. And in that, they kind of restated this idea that the governing documents of a homeowners association constitute a contract. And they were citing Swan Creek. But in the Kelly case, one of the arguments that was brought by the homeowner was that the association breached first. Now, the argument that they made wasn't a good one. They didn't formulate their prior breach argument very well, and so they lost. But it does kind of leave this question: if they had brought a better prior breach argument, could they have said that they don't have to follow the rules? And I think that there's a real argument for that. So that's one of the places that HOA contract theory can take us. That is probably not what would be expected by HOA attorneys otherwise, or by most folks. And I think that it can take us in even stranger directions. So one of those is, can an HOA enforce parking on a public street? And I'm going to share a story here that I think illustrates this well. And it actually affects Craig because it was his brother. So as fate would have it, I practiced law at Anderson, Collin Wilkinson. I got great mentorship from Craig, loved being around him, the other attorneys there. And then the neighborhood that I moved into, Craig's brother Lance lived there. And Lance is a lot like Craig. He's this very dignified but quiet person. He's not somebody that jumps in front of you and says, look at me, but quickly earns your respect because he's a smart guy. He's kind and respectful of other people. And so I really liked Lance. But he and I got into a small disagreement because I was on the HOA board and Lance was parking his car in the road, or at least his son was. And don't ask me how I ended up. I was actually the president of this HOA board. Don't ask me how that happened, because you would think that somebody who knows enough about HOA law, that they had been an attorney and they'd been a property manager, that they would know better than to get on the HOA board. And in fact, I did. I had told them for years that I would not serve on the HOA board for a number of reasons, and largely because I knew how awful it could be. But they wore me down, and some of the circumstances why I said I don't want to be on the board changed. And so I found myself as the president of our HOA. And so when there was this concern, when Lance was receiving these notices, he came and talked to me. He says, Jeremy, hey, what are you guys doing here? Why are you telling me that I can't park on a public road? Now, one thing about Lance is Lance was the chief of police of American Fork. So he understood law enforcement really well. And he said, you know, you guys don't own the road, so you can't enforce a property right here. And that was true. And he said, and also, you guys aren't an enforcement agency. You don't have the police power to act for the city or for any sort of local government agency. Also true. And I admitted all these things. I said, you're right on those things. And he says, so how are you saying that you can prohibit me from parking on a public road? And the way that I think that happens goes back to this contract theory, because while I can't enforce, and the HOA can't enforce property rights on property it doesn't own, or enforce the police power, we can enter into contracts, right? So let's say that my neighbor across the street, his name's Greg Hill, wonderful guy, coolest person you could ever meet, but he has this annoying habit of parking in the road, right in front of my house. I don't know why he doesn't park in front of his house, but he parks in front of my house, and it makes it difficult for me to back up out of my driveway. I'm a little bit worried that my crazy 5-year-old kid is going to jump out from behind one of his cars and potentially get hit. And so I go to Greg and say, Greg, I know that I can't tell you where to park on a public road, but what if we enter into a contract? I'll pay you a monthly amount to not park on my side of the road. Can I do that? I enter into that contract. And I think that absolutely I can. Why wouldn't I be able to? And if as part of that contract, I said, hey, if you violate it, then I can tow your car. Again, I think that I could do that. And so this was the explanation that I provided to Lance, and said, you know, I think that what we've got here is a contract that you have agreed to enter into by purchasing your lot. And so I do think that we can enforce this. And in fact, there are states where the courts have examined this very issue and have said, like, for instance, in New Jersey, that HOAs can enforce public parking on public streets based on this contract theory. Now, I will also note that just recently in Florida, they examined this issue and they came up with a different conclusion. And I think they make a pretty good argument, because they make the distinction between a regular covenant or a regular contract and covenants that run with the land. And they kind of argue that because restrictive covenants run with the land, then the terms of this covenant have to be related to the land in question. And in this Florida case's opinion, that wasn't really true for the public roads. Now, Utah might come down differently because of this unique language we have, that the governing documents of an HOA constitute a contract, not just they're construed as one, but they constitute a contract. So anyway, HOA law takes us in a lot of interesting directions based on that part of the animal that we're focusing on. So when we look at HOA and HOA laws as contract theory, it can take us to the ability even to enforce parking potentially on public streets, which I think it would be surprising to, I know that it's surprising to a lot of people because I had to enforce that in many different HOAs. And I would get this argument probably 20 times. Well, it's a public street. And I would have to explain this contract theory. Now, Utah hasn't Utah courts haven't specifically examined this. So there is some question how they would treat this. But again, I think that because of this language in the Swan Creek case and in the Kelly v. Timber Lakes case, that they probably would come down the way that the New Jersey court did, but we don't know. Now, but as we talked about earlier, the HOA elephant has a lot of different aspects to it. Contract law is one way to understand what an HOA is, but there's others. And one of those is that HOAs are also a creature usually, well, actually always, of nonprofit law, though to different degrees depending on whether or not the HOA has actually been incorporated as a nonprofit. So both the Community Association Act and the Condominium Ownership Act expressly acknowledge that an association whose governing documents have reference to the ability to incorporate or organize a legal entity can be a nonprofit corporation. And I would say that because of that, associations usually can, and that they absolutely should become nonprofit corporations. In fact, I will tell you that in my experience as a property manager, I want to say we probably managed at one given time, if you said, how many do you manage right now? You probably say we managed 200 associations. And some of those were massive associations that had thousands of homeowners and multiple clubhouses and pools. And of all those associations that we had, that might have been 200 at one time, but many more than that over the 10 years that I managed, 99.5% of those were all organized as nonprofits. And in fact, even many of those associations that didn't have provisions in their governing documents acknowledging or permitting them to be nonprofit corporations organized as nonprofits anyway. And I think that all of that begs the question of why there would be such a strong preference to be a nonprofit corporation as an association. And there's a couple different answers. Probably the most important and prevalent answer is protection. And that protection comes through the business judgment rule. When you are on an HOA board, you often get people to disagree with you. And in fact, I would be shocked if you served for a long time where multiple people didn't have pretty serious disagreements with you. And that can take the form of litigation. I've got an association up in Park City, and they recently had to do a massive special assessment to cover the cost of redoing a lot of the roofing and landscaping throughout the project. And immediately, as soon as you touch people's pocketbooks, they get very concerned. And so you had all of these homeowners in Park City who are used to kind of getting their own way. They're usually pretty successful people and well off, disagreeing with this board and saying there's no way that we want to fund this massive cost. We don't think it's necessary. We think there's better ways to do it. And they were talking about suing the board. Well, who wants to serve on a board, on an HOA board at all, but especially if you can be liable for the decisions you make. And so, and this is true not just of HOA boards, but all sorts of boards, corporate boards, nonprofit corporations. Nobody's going to want to serve if they can be liable for their decisions. So we have the business judgment rule. And then again, for those who aren't familiar, I'm going to just briefly explain that the business judgment rule, and in Utah, it's been incorporated into statute, codified into the Nonprofit Corporation Act. It essentially says, hey, look, we're not going to hold board members liable so long as they meet fiduciary duties and they don't act with willful misconduct, intentional infliction to inflict harm, or gross negligence. And that becomes really important because we want to get people involved in participating, and we don't want them to be liable for any little thing. Now, the duties that this board has are a duty of to act in the best interest of the association, to make sure that I'm going to go back up here. Okay, so it's a duty of good faith, the duty or the care of an ordinarily prudent person in a like position under similar circumstances, and then acting in the best interest of the association. Those are the duties that are mentioned here in the Nonprofit Corporation Act. But if an association was not organized as a nonprofit, they wouldn't always necessarily have this protection. And that's a huge deal. And so, again, I would tell any association to try and organize as a nonprofit corporation. And if your governing documents don't mention it, you should amend your governing documents so that they do permit you to organize as a nonprofit, just so you can avail yourself of this protection, if nothing else. But there are also other reasons why it is important to, and I think advisable to, become organized as a nonprofit. And that is because there are significant connections between association law and nonprofit corporation law. And I've listed some of them here. This is the Condominium Ownership Act. And it has 16 references to the nonprofit corporation incorporated into it. Some of those automatically apply, and I've shown where those are. Some of them only apply if the association is incorporated as a nonprofit. And some of those have to do with well, some of the automatic ones, probably the most important automatic ones that apply, have to do with what records the association has to keep and produce, and then notice requirements. And then some of the ones that are most important that only apply if the association is organized as a nonprofit have to do with the hierarchy of which laws apply compared to other laws and the governing documents. And then also indemnification provisions, which are pretty important because they can come in and help protect the association as well. So there's a lot of really good reasons to incorporate as a nonprofit. And because of all these, and this is the Community Association Act, which is identical, except that there's one other reference to the Nonprofit Corporation Act. But all of these show, one, that associations have this tight connection with nonprofit corporation, and that nonprofit corporations are a creature, or that associations are a creature of nonprofit law and nonprofit corporations. Now, there's a whole bunch of other parts of this elephant that is an HOA. I mentioned, and you've got collections and other things. We're going to have some of the presenters explain those in more depth later on. But to me, the most important part of the elephant that is HOAs is to remember that associations are communities. And hopefully this is where my kind of practical experience being a property manager can be helpful, because I'm sure you've all heard nightmare stories about HOAs. And I think that those happen when we forget that part of this elephant, part of HOAs are that we're communities and we're all neighbors. And this can happen in at least two ways. Probably one of them jumps out to you right off the bat. You maybe experienced it, or you can just come up with it thinking about it. And that is that if I'm on the board and I forget that the person that I'm talking to who may have violated the governing documents, if I forget that they're my neighbor, I can be sort of, an HOA Nazi. Or if I'm a homeowner and I don't like what the board's doing, I don't like that they're telling me I have to mow my lawn, I can forget that they're a part of my community, and I can become really belligerent and combative and problematic. And all of a sudden, these neighbors end up fighting and things escalate and it gets really crazy. And I think that's true. And so I think that that's an important way to remember that HOAs, part of HOAs and HOA law is that we're neighbors and we're communities. Another way that this happens, if we forget this community aspect of HOAs, is apathy. And I'm going to share a story this is like the ultimate cautionary tale of what can happen if we forget that an HOA is a community and we don't become involved with each other and with taking care of that community. So there is an HOA in Orem, Utah, and it was mostly populated by kids in school and kids or people that had just, and when I say kids in school, I mean college. And I'm getting old now, so I can say that. And people that were just starting their profession. So really busy people. And they weren't super involved in the HOA because who would want to be? And something happened as a consequence. There was this vacuum, and it was filled by a guy. I'm going to make up a name, Robert Browning. It was filled by this guy, Robert Browning. And Robert was nuts. He was absolutely crazy. And Robert became the board president. He orchestrated things so that one of the second board members was a guy that was renting a bedroom in Robert's condominium unit, which was in violation of governing documents in two ways. One, he wasn't supposed to be renting less than his whole unit. He wasn't supposed to be renting out just a room. And two, you couldn't be on the board, or at least in a condo, it's called a management committee. You couldn't be on the management committee unless you owned the unit. So he owned the unit, but the guy renting his other bedroom didn't. So this guy wasn't supposed to be on the board, but as you'll see, that was not following the HOA rules wasn't important to Robert, even though he was the board president. And then, and Robert kind of manipulated and controlled this second person because they owed him money as his tenant and hadn't paid for a while. And Robert kind of said, well, I won't kick you out basically if you do what I say. And so Robert and this guy froze out the third board member who really wasn't engaged anyway. And they just started to completely run the HOA. And what running the HOA to them meant was some of the following. One was Robert became security for this condominium association. He paid himself to be security, and he bought guns so that he could be security with HOA funds for himself. And he walked around the common area of the HOA with a gun to protect people. Well, the homeowners did not feel safe, despite his best efforts to protect them. And they became concerned, and they started to talk. And then things got worse. All of a sudden, the pool for the condominium association got closed down because it was electric green, because it hadn't been taken care of. And the lights to the clubhouse and throughout the complex got shut off because bills weren't being paid. And the homeowners got really concerned and finally decided that they had to do something. And so they went to Robert and they said, hey, we want to see our financials. we want to see minutes, and we want to hold an annual meeting. Obviously because they wanted to get Robert out. And Robert said no. And they said, well, what do you mean? You have to do these things. He said, no, I'm not going to do that. So they came to me and they said, we really need help here. We feel like we're being held hostage at gunpoint. And so we filed a complaint in the 4th District Court and started to bring legal proceedings against Robert. And Robert hired an attorney, which was the best thing that could have happened, because Robert was nuts, but his attorney was a reasonable person. So we started working with the attorney. He told Robert, look, you've got to give them documents. It's required under the statute. You've got to hold an annual meeting. It's required under the governing documents. And so we did that. We got Robert out, found out that he'd been embezzling money. Robert went to prison. And ultimately we got back control of the HOA. But all this massive problem happened because people forgot that an HOA is a community, and that communities mean you've got to be connected to your neighbor and you've got to be engaged. And I actually think HOAs are really valuable in our society. They can be done wrong, but I think that they can significantly protect property values and even bring communities together. I've seen HOAs that have worked fantastically that way. And so all of this is kind of done as an introduction to help you understand, kind of in a basic sense, what HOAs are. HOAs are creatures of contract. They are creatures of nonprofit corporation. They're communities. They involve things like land development. They involve collections and a whole host of other things. Our presenters today are going to explain a little bit more in detail how some of those